My name is Kathleen Regan, and now I'd like to introduce today's speakers. Sarah Sally Church is a special counsel at Saul Ewing and brings to her clients 25 years of experience in working on a wide spectrum of employee benefits and executive compensation matters. Lori Clary serves as in-house employment counselor for Reed Elsevier Incorporated, where she works closely with human resources personnel and business leaders to improve workforce relations and resolve employment disputes. Catherine Walters is a partner in Saul Ewing's Business and Finance Department. She represents employers, both private and public, union and non-union, in all areas of labor and employment law. Panelists, the floor is yours.
Thank you so much, everyone. This is Lori Clary. Welcome to our webinar today. We're very pleased to see so many attendees and such interest in the issue of same-sex marriages and how a recent Supreme Court decision has really changed that landscape and given employers some work to do on their end. So just to briefly overview what we're going to discuss today, we're going to first take a quick look at the Defense of Marriage Act, or DOMA. Then we're going to look at the particulars of the Windsor decision. And then we're going to talk about how that decision has impacted all sorts of different laws, regulations, etc. In addition, we'll then go on to talk a little bit about some of the action steps that employers need to take to maintain compliance with the latest state of the law. As mentioned earlier, we're very interested in any questions you may have, so we encourage you to submit those through the webinar website, and we'll try to get to as many of those as we can. This story starts with the Defense of Marriage Act, DOMA. It was enacted in 1996, and what's interesting about that is that that was before any state or jurisdiction had approved or enacted legislation to permit same-sex marriage. We had some different states that had domestic partner benefits and that sort of thing, but no states had actually recognized same-sex marriage yet. For our purposes today, there are 3 sections to DOMA, 2 of which we'll spend some time talking about. Section 2, which reserves certain powers to the state, and Section 3, which purports to offer a definition of marriage and spouse. So Section 2 of DOMA reserves certain powers to the states, and what it says in a nutshell is if one state permits same-sex marriage, other states don't necessarily need to recognize that. As you'll see in the language there, no state shall be required to give effect to any public act of any other state respecting a relationship between persons of the same sex that is treated as a marriage under the laws of such other state, or a right or claim arising from such a relationship. There's a lot in there. The definitional provision of Section 3 of DOMA seems much more innocuous, but it goes ahead and defines marriage and spouse. And what's interesting about this is that in so doing, it impacted over 1,300 federal laws, rules, regulations, orders, etc. And what Section 3 of DOMA did was to say that in determining the meaning of any act of Congress, the word marriage means only a legal union between one man and one woman as husband and wife, and the word spouse refers only to a person of the opposite sex who is a husband or a wife. And so those 2 sections of DOMA really worked to define marriage only as an opposite sex relationship. So that was 1996. And again, DOMA, through those 2 relatively brief provisions, impacted over 1,300 different federal laws. We're going to explore how DOMA impacted some of those different laws a little bit later in our presentation, but I think that that's very interesting that it had such a wide impact, almost exponential. So now we'll fast forward to the year 2009, and in 2009, a woman named Thea Spire passed away. Thea Spire was married to Edith Windsor. They both lived in New York, and they'd been together since the early 1960s. In 1992 or 1993, Edith and Thea registered as domestic partners under New York law. But as Thea's health began to decline in 2007, Edith and Thea went to Canada and were married under the laws of Canada. They then returned to New York, which, although it didn't yet recognize same-sex marriage, nonetheless had provided that any marriages entered into in other jurisdictions would be recognized by New York law. Once Thea passed away in 2009, she left her estate in its entirety to Edith Windsor, her spouse. Upon her inheritance of that estate, Ms. Windsor ended up paying an estate tax of more than $360,000. She requested from the IRS a refund of that tax based on the fact that she believes she should be eligible for the spousal deduction. The IRS refused to give her her refund, in part because of the way that DOMA had defined the word spouse and marriage. When the IRS refused to give her the refund, Ms. Windsor filed suit in the Southern District of New York. And in so doing, she asked for the refund of the estate tax that she paid, and she asked that DOMA be declared unconstitutional because it operated in a manner to deprive her of her rights. Now, at this point, the case becomes interesting on one of many levels. When the case was filed, the Obama administration, in conjunction with the Attorney General, indicated to Congress that although it would continue to enforce DOMA, it would not defend this particular lawsuit because they believed it to be unconstitutional. Now, that in and of itself is not particularly unusual for an administration to take that position, but what was unusual here was that there had not yet been any court decision which had declared that DOMA was unconstitutional. However, upon giving Congress that notice, there were other parties that intervened in order to oppose Ms. Windsor's claim for the refund and her attack on the constitutionality of DOMA. Ultimately, the Southern District of New York ruled in Ms. Windsor's favor. The opposing parties ended up appealing to the Second Circuit Court of Appeals, which affirmed the lower court's decision. The U.S. Supreme Court then granted certiorari. And in a 5-4 decision, they ruled that Ms. Windsor should obtain the refund, the IRS refund, and they ruled that Section 3, not Section 2, of DOMA was unconstitutional. In so ruling, the majority essentially found that DOMA was enacted solely for the purpose of favoring opposite-sex marriage and disfavoring same-sex marriage. One of the interesting sentences in the opinion was that in recognition of DOMA's reach, the majority said that DOMA writes inequality into the entire U.S. Code. And again, this goes back to the fact that DOMA impacted over 1,300 statutes. The court found that there was no legitimate governmental interest in those provisions of DOMA and therefore found that it couldn't be upheld on constitutional grounds. Now, the DOMA, or the Windsor decision, included many other aspects of constitutional law, including some very interesting arguments regarding standing. But for our purposes, we need to focus on just a few of the points in that holding. And essentially, that was that Ms. Windsor was entitled to the IRS refund and that Section 3 of DOMA was impermissible. Now, that's what Windsor did, but it also left a lot undone. It didn't provide any guidance for employer-sponsored benefit plans. It didn't provide any guidance for how federal laws were supposed to impact or implement this provision of DOMA being declared unconstitutional. And it said that you would continue to look to state law to determine the validity of marriage. In fact, the Windsor decision was actually quite narrow in its holding and held only that if a same-sex couple is married in a jurisdiction that recognizes same-sex marriage and the couple lives in a state that recognizes same-sex marriages, they're married for purposes of federal law. And with that holding, to which there were vigorous dissents, the Supreme Court unleashed on us a number of different questions that relate to how this should be implemented, and in particular, how employers should implement it in their personnel policies and in connection with their benefits plans. To add to this complexity, the legal landscape continues to change. I'm going to turn it over now to Catherine so that she can talk a little bit about what the legal landscape looks like today and how that is going to impact the effect of the Windsor decision going forward.
Thank you, Lori, very much. All right, now, basically I'd like to say let's just start with that current legal landscape. As you can see on the slide, currently 16 states and the District of Columbia recognize same-sex marriages. Now, 3 of the most recent newcomers, as you can see, New Jersey, Hawaii, and Illinois, already recognized civil unions, so the step up to the same-sex marriage recognition was not as much of a drama or a dramatic step as perhaps in other jurisdictions. Now, interestingly, the same-sex marriage was recognized through various means, including via legislation, which is actually 8 of those states plus the District of Columbia, via court decision, which is actually 5 of those states, and via popular vote, which is 3 of those. And in essence, just briefly, the ones that were recognized via statute include Delaware, Minnesota, Rhode Island, Hawaii, Illinois, Vermont, New Hampshire, the District of Columbia, and New York. The ones recognized via vote were Washington, Maine, and Maryland. And California is a special kind of situation. California actually began recognizing same-sex couples or issuing licenses to same-sex couples in June of 2008 as the result of the Supreme Court of California's ruling in a case called in re marriage cases. In that case, the state of California, or the courts, found that barring same-sex couples from marriage violated the state's constitution. And so California began issuing marriage licenses. However, those licenses were halted during the period of November 2008 through just recently in June of 2013, even though existing same-sex marriages did continue to be valid. And the reason they were halted was the passage of Proposition 8, which was a state constitutional amendment that barred same-sex marriages. However, same-sex marriages recommenced following the U.S. Supreme Court's decision in a case called Hollingsworth versus Perry, which restored the effect of a federal district court's ruling that had overturned Proposition 8 as unconstitutional. And in essence, we see that California really was only the second U.S. state after Massachusetts to permit same-sex marriage. However, marriages granted under the laws of other state governments have always legally been recognized and retained state-level rights. So what we see really is a movement towards a recognition of same-sex marriage. And so the next slide really kind of raises the question of what is to come here. And what we really see is more states will come online as a result of Windsor. I don't know that there's going to be a lot of choices. Sally's going to be talking with you, of course, about a lot of the employee benefits issues, and it seems to me that those are perfectly reasonable reasons why more people will seek to push same-sex marriage through so that it's recognized in a broader variety of states. But not every state will participate regardless of the fact that more states are coming online. Look at, for example, New Mexico. We expect that New Mexico will be one of the next ones on, but the state itself doesn't currently recognize same-sex marriage, even though 8 counties do. So in essence, we're going to see more folks joining this group. We're going to see a number of holdouts. And there's always going to be a difference among the states, and there's already a morass of varying state legislation with different impacts, especially in the tax arena. Now, these types of variations, along with clashes that relate to the recognition of same-sex marriage by state of celebration versus state of domicile, are going to continue to create numerous inconsistencies and disparities with respect to how people are treated from locale to locale. And so I think that what is going to occur are going to be more difficulties, really, not only for the people involved in those relationships, but employers, for example, are going to be faced with a growing need to understand more state laws relevant to marriage, relevant to whether a state recognizes same-sex marriage, and I'll speak more about that issue later, and it really has more to do with the state of domicile recognition versus the state of celebration, and we'll be talking with you about why the clash between those two types of recognition are going to be problematic going forward. And then, of course, we see status issues. All couples, same-sex couples, opposite-sex couples, they engage in different types of behaviors, including divorce, including changing of benefit elections, including dying and leaving wills and goods behind, taxes, employment issues, and the beat certainly does go on. Now, in essence, under federal law, we basically typically see that the way of recognizing marriage is either through the state of celebration, meaning where the couple actually got married, or the state of residence or domicile, i.e. where does the couple live. And this is historically what the IRS has used for making decisions about marriage and tax matters and so forth. But we're going to really be seeing, because you're going to hear about the difference in how the federal and state governments recognize marriage, i.e. versus domicile versus celebration. You're going to be hearing more about some of the difficulties that we'll be encountering. And of course, as attorneys, as accountants, for example, employers, tax advisors, courts, legislatures, and so forth, will be tasked with trying to work through these numerous issues that are caused by the disparate approaches with respect to recognition and treatment of same-sex marriage. So again, how do we unwind this? We really look at the concept of the state of celebration and the state of residence for the resolution, and then each statute will likely, we hope, recognize whether it's celebration or domicile that controls. And I think I've made somewhat clear already that where the rules clash is where we're going to have some issues. For example, as you can see on the slide, what about a couple who is married in a state like Delaware that recognizes same-sex marriage, but now they live in Pennsylvania? And Pennsylvania is really the last holdout in the northeastern U.S. In fact, Pennsylvania doesn't recognize same-sex marriage, doesn't recognize civil unions, and abolished the concept of common law marriage some years ago. And speaking of common law marriage, what about it? In essence, common law marriage can still be contracted in 9 states, including Alabama, Colorado, Kansas, Rhode Island, South Carolina, Iowa, Montana, Utah, and Texas, as well as the District of Columbia. New Hampshire recognizes common law marriage for purposes of probate, and Utah recognizes it only if it has been validated by a court or an administrative order. Now, when I read off that number or those states, you only heard a couple of states that also recognize same-sex marriage. That includes Rhode Island, Iowa, the District of Columbia, and New Hampshire. And it's interesting to note that while a number of U.S. states do recognize same-sex marriage or domestic partnerships and recognize the same legal incidence as marriage, none of the U.S. states except Iowa and Rhode Island currently recognize same-sex common law marriage. So it's just another twist to all of this. And I think that it's interesting to note that even states that have abolished the contract of common law marriage in their boundaries do recognize common law marriages lawfully contracted in jurisdictions that permit it. And so this is because the validity of foreign marriages are determined by the law of the place of celebration. And in essence, the law of the state of celebration is probably a little broader and easier to administer, and it's the rule that has been adopted by the IRS, which Sally will discuss in a few moments. But in the meantime, the IRS had recognized common law marriage for federal tax purposes if it is recognized by the state where the taxpayers live or the state where it began. So if the marriage is recognized under the law and the customs of the state in which the marriage took place, then the marriage is valid. And so this issue plays into the law of the domicile versus celebration issues. And I think that, again, as Sally will discuss, the IRS has clarified its perspective on same-sex marriages with respect to celebration. And I'm suggesting that common law marriages will probably roll right into the same type of treatment. Note, too, that I said earlier that we're going to see status changes and things like that developing as time passes. There's no such thing as a common law marriage or, a common law divorce. You can't get out of a common law marriage as easily as you can get into one. And so we're going to be seeing more issues along the same lines as the same-sex marriage. We'll be seeing more issues relevant to the common law divorce. I read an article recently about a woman who is seeking a divorce in Tennessee simply because she is attempting to get Tennessee to recognize the fact that a same-sex marriage exists. So she's out there attempting to make a little bit of new law on behalf of the same-sex relationships. Okay, now, having spoken about the concept of the rule of domicile and the rule of residence, let's turn briefly to the concept of the Family and Medical Leave Act. Recall that the Family and Medical Leave Act applies to employers with 50 or more employees. And I'll be talking a little bit more about the FMLA further down the road here, but this is an interesting issue because under fact sheet number 28, which was issued in August of this year after the Windsor decision came out, the Department of Labor recognizes that the FMLA regulations provide that the, quote, state of residence, closed quote, controls marital status. And so the FMLA regulations define spouse as meaning a husband or wife as defined or recognized under state law for purposes of marriage in the state where the employee resides, including common law marriages in states where they are recognized. And this is an issue, and it sounds somewhat simple, but when we look at the FMLA and its current claim to use state of residence or domicile as the rule, and then we look at the next set of issues that Sally will discuss, we're going to see even more confusion and more difficulty with respect to how to administer multiple types of employee benefits and employment-affiliated leave and other types of non-ERISA controlled benefits. So Sally, why don't we turn our attention over to the Windsor decision's effect on employee benefit plans and take it from there.
Thanks, Catherine. This is Sally Church, and I'm going to try not to get down in the weeds too far on this, but anytime you're talking about tax laws, it sometimes turns out that we have to a little bit. Catherine just pointed out that despite the Supreme Court opinion in Windsor in June, in August, we have the Department of Labor coming out and say, hey, at least for FMLA purposes, we're going to look at where the employee resides in order to control the definition of whether someone is truly a spouse. So really, in between, or when the opinion came out and that advice that came out from the Department of Labor, all we could really tell employers was, for federal tax purposes, based solely on this Windsor decision, if a same-sex spouse is going to have to be treated the same as an opposite-sex spouse, as long as they're legally married in any state or foreign jurisdiction that permits same-sex marriage, and they live in the state that permits same-sex marriage. So in other words, all we knew that if you got married in a state that recognized it, and so you were married in a state that allowed the celebration in that state, and you now live in a state, we knew that you should probably be, for federal tax purposes, adhering to those to the rules of treating the same-sex and opposite-sex spouses the same. Now, in between the issuance of this decision and the DOL information on the Family Medical Leave Act, in July, a number of senators sent a letter to the White House, and they asked the President to swiftly and comprehensively implement the Windsor decision, and they asked that the President ensure that legally married same-sex couples would be treated equally under federal law, regardless of where they live. So in other words, they were asking that the federal government adopt this state of celebration rule. And about the same time, the American Benefits Council, on behalf of all their members, sent a letter to the Treasury Secretary, the Acting Secretary of Labor, the Secretary of Health and Human Services, and the Acting Commissioner of the Internal Revenue Service, also advocating the state of celebration rule. So finally, on August 29, 2013, the Internal Revenue Service started issuing some guidance. And this took the form of a news release, a revenue ruling, and frequently asked questions. Now, a copy of the revenue ruling, 2013-17, is part of the handouts. The frequently asked questions are the website. The link to get those is going to be at the end of the slide presentation. And some of those frequently asked questions have recently been updated with some additional information. Remember now that when we look at what the IRS is saying in its Windsor guidance, if we want to call it that, it really only relates to federal tax laws. Catherine mentioned that the state laws are all across the board, and they're going to fall into a number of different categories. Some states don't have any income tax. Some states conform their state law to federal law, but even some of those states are starting to come out and announce we're not going to follow federal law with respect to treating a same-sex spouse for state tax purposes like the feds are going to do. So again, it's going to be all across the board. All right, let's look at, from the standpoint of an employer, the marital status of an employee is going to be very important because there's certain tax benefits that apply to a spouse of an employee. So it's going to impact payroll, and it's going to impact benefits administration. So when this revenue ruling came out, the Windsor decision, it looked first at definitions and concluded that terms like spouse, husband and wife, that included an individual married to a person of the same sex if they were married under any domestic or foreign jurisdiction that had the legal authority to sanction the marriage, and that the marriage included a marriage between individuals of the same sex. Next, they said that for federal tax purposes, the IRS would recognize this marriage, if it was validly entered into, in a state or foreign jurisdiction that authorized it, even if the individuals live in a state that does not recognize the same-sex marriage. So for federal tax purposes now, the state of celebration rule applies. In issuing the guidance, the IRS looked back for many years to a ruling that it issued back in the 50s, and this related to common law marriage, as Catherine mentioned, that, okay, what do we do about common law marriage? In that ruling, the service determined, at least for federal income tax purposes, if people had entered into a common law marriage in a state that recognized it, they'd be treated as married, even if they lived in a state that didn't recognize common law marriages and would have required a ceremony to establish that marital relationship. So part of what the IRS was hanging their head on is, you know, with common law marriages, we finally concluded that it was just too confusing, not for federal tax purposes, to treat these people as married, even if they moved someplace where common law marriages were not recognized. So that was part of the reason for the position they took. They also mention in the guidance that they recognize that we have a mobile society, and it's so important that the federal tax rules, there's some uniform rules for both the taxpayers and for the IRS. Then the Windsor guidance, this revenue ruling, went on to specifically mention the administrative and financial burdens that would be placed on employers that operate in more than one state if the federal government adopted the domicile rule, basically saying this is going to be unmanageable for employers. Then the service went on to say that using the state of celebration rule would also have a positive impact on the employee benefit plan administrators that would need to know whether such things as the elections and spousal consents are valid. In other words, benefit plan administrators need to know what marriage really means, and that shouldn't mean something different just because on a state-by-state basis. Specific benefits and fringe benefits were mentioned in the guidance, including health coverage, tuition reduction benefits, meals and lodging furnished for the convenience of the employer, dependent care assistance program, and other fringe benefits. Now, the guidance indicated that we're not going to apply this retroactively, basically. So starting September 16th, you need to get your ducks in a row for federal tax purposes and make any changes you need in order to comply with this guidance. Now, when I say generally applies prospectively, it also said that as long as a taxpayer, the statute of limitations had not expired for filing tax returns or amended returns or a claim for refunds, we'll let you do that. And I'll explain in a minute when that it really is even relevant. And the details are actually in a notice 2013-61, and that is also in the handout package on the website. Now, individuals who've entered into domestic partnerships, civil unions, or other similar formal relationships that are not designated as marriages in any state even if that state recognizes those relationships under state law, they're not going to be subject to these same rules. Only individuals who are in a legally recognized same-sex marriage are going to get the benefit of this celebration rule and the guidance. Now, we're also still waiting to see whether there's going to be any specific retroactivity, especially with respect to retirement plans. Let me give you an example. Let's assume that John came in and retired last year, and the employer has a defined benefit plan, and John was married to a same-sex partner. But the employer's defined benefit plan didn't allow John to select any form of joint survivor annuity with anyone but a spouse. And at that time, a spouse didn't include John's same-sex spouse. So now, will there be rules that come out that will permit John to make another election? Can he go back and say, I really want to designate my same-sex spouse as my joint annuitant? And this would require recalculation of the benefit. Will the plan need to be amended to provide that a spouse is a same-sex spouse? So, especially where plans limited the term spouse to that old DOMA definition, you know, a marriage and a spouse means, you know, marriage between a man and a woman, those plans are going to have to be amended. Now, again, the guidance that we got from the IRS in August does not speak to when those plan amendments have to be done.
Sally, I had a quick question for you.
Sure.
And I'd be interested in your and Catherine's thoughts on this. We talk about state of domicile and state of celebration. As a practical matter, how do employers go about figuring out what the state of celebration is? You know, what questions can they ask? What documentation can they require?
Well, I think that's an interesting question, because what you don't want to set yourself up to, and Catherine being more of the employment lawyer than I am, more of a benefit lawyer, I would think that you would not want to require something to be provided by someone in a same-sex marriage that you do not require of an opposite-sex marriage. In other words, if someone just has to say, I'm married, are you going to make someone who claims they have a same-sex spouse provide something that that you don't require of someone who's in an opposite-sex marriage? I don't know whether Catherine has a perspective on that or not.
Well, I agree with exactly where you're headed, and in essence, many employers have established the practice of requesting anyone who claims to have a spouse to supply evidence or proof of the marriage. So, for example, before same-sex marriage was an issue, really, around the states, and common law marriage was the big deal, employers initiated a whole practice of having individuals who claimed to have common law spouses, of having those individuals fill out various questionnaires and acknowledgments, including the acknowledgment that should my common law marriage terminate, then I understand that under the laws of the Commonwealth of Pennsylvania, I will have to proceed with a legal divorce. And that was intended back then to prevent people from signing up their then live-in boyfriend or girlfriend or whatever it was, based on the concept of, oh, we're married common law. So we started asking for those types of certifications. Now, with the concept of common law marriage, same-sex marriage, and opposite-sex marriage, I would suggest that employers consider requesting certification of the marriage or proof of the marriage in all instances from all applicants for benefits or all benefit participants. except for those that, currently are recognized within the plan. But I think, as Sally points out, you don't want to isolate one group over another requesting this type of proof. So if you're going to ask for proof of a marriage, you should ask for it across the board, regardless of the fact that same-sex marriage is a new concept for many states. I would suggest that you begin moving towards requesting proof of marriage across the board, regardless of the sex of the participants.
That sounds good. Thank you. Thank you.
Okay. Now, as I said, this notice 2013-61 is in your packet, and this one does get down into the gory details of how to file for tax refunds. But let's make it clear that if you're an employer and never provided benefits to same-sex spouses, and remember, in some cases, if you had provided domestic partner benefits, some employers allow someone to get benefits under the guise of domestic partner benefits if they were in a same-sex marriage, because they really couldn't treat that same-sex spouse as a spouse under the federal tax laws or some of the rules for benefit plans. So if you've never provided benefits to anyone who would have had a same-sex spouse, you don't have any need to seek refunds as an employer. And you got to remember, if you do offer domestic partner benefits, those rules are going to stay the same. You still need to impute income and require people to pay benefits on an after-tax basis for coverage. So if you provided same-sex partners with certain welfare benefits, that's the only trigger for the filing of tax refunds. And some employers provided health care benefits, again, to same-sex, or provided domestic partner benefits to same-sex spouses, and allowed that prior to the decision. But if they were not a dependent, and most spouses or same-sex spouses are not a dependent, the result was an employer's contribution toward the health care coverage was treated as taxable income to the employee. And the employee's own contribution to cover that same-sex spouse couldn't be made through a cafeteria plan election on a pre-tax basis. And this meant that the employee had to pay taxes on the contributions that were required to cover his or her same-sex spouse. And this also meant that both the employee and the employer were required to pay FICA taxes on those amounts. So in situations where an employer didn't offer any same-sex benefits and or domestic partner benefits, you don't have to worry about it. If you offer domestic partner benefits and you don't know if that domestic partner was also a same-sex spouse married in, for example, another state, then you might want to send out a notice to find out what their status is. The problem is some employers are reluctant to ask people to disclose their marital status, especially with respect to same-sex marriages. Generally, if somebody wants to file for a refund, the timing is, statute of limitations is 3 years from the filing date of the return, or 2 years from the tax payment date. And there is really not an obligation for any employer to take action, but to the extent you may have a large population of employees that are in same-sex marriages, they may come to you if they're going to file for tax refunds, at least asking for some information on what the tax, the differential was that they had to pay related to their welfare benefits if they can't find any records on that. All right. After the IRS said, we're going to use state of celebration, so basically anything that provides a tax benefit in your welfare benefit plan is going to, or in your retirement plans, we are going to, you're going to make sure that the plan provides that benefits. After the IRS came out with their guidance, the Employee Benefit Security Administration of the Department of Labor came out with a technical release. And again, I think that technical release is in the handouts in September, and it was issued to benefit plans and sponsors, fiduciary participants about what spouse and marriage meant under ERISA. And they adopted the same rule as the IRS, that it's the state of celebration rule that applies under ERISA. In other words, they concluded that this is promoting the uniformity in administering plans. And from an employer standpoint, especially employers that have employees in numerous jurisdictions within the United States, it is a good thing because it does at least eliminate the burden of having to do this state-by-state analysis. Okay, so now that we've got some guidance, what are you required to do? If you were imputing income to employees and withholding taxes for covering a same-sex spouse, that had to stop effective September 16th. And if you are allowing someone to pay for health coverage of a same-sex spouse, and it was on an after-tax basis, and you maintain a cafeteria plan, you now have got to convert that to a pre-tax contribution. Again, those rules became effective September 16th, and any retroactive application is really unknown at this point. Stay tuned, in other words. Okay, we're going to move on. Yeah.
We had a question from an audience member about whether or not the Department of Labor Technical Release 2013-14, whether it requires employer health plans to cover same-sex spouses if they cover opposite-sex spouses. No. The answer is no. And I'm going to handle that. Let me see if I can answer that quickly. First of all, there's no requirement, and I'm going to cover this a little bit later, there's no requirement under any law that requires an employer to provide any type of benefit, including health care benefits. And contrary to popular belief, even the Affordable Care Act doesn't require an employer, any employer, to provide health care benefits. But what the Affordable Care Act will do in 2015 is if a large employer with over 50 full-time employees doesn't offer what's called the minimum assistable coverage to at least 95% of their employees, or offers coverage that isn't affordable to their full-time employees, or doesn't provide a very good level of benefits, it's called minimum value, the employer could get penalized if employees go to the marketplace and qualify for subsidies. Those subsidies take premium tax credits, or cost-sharing reductions. So step one is you never have to provide health care benefits. Step two, you could get penalized for it if you're a large employer in 2015. But the Windsor decision and none of the Windsor guidance does not require a state insurance commission to issue policies that require coverage for same-sex spouses. And a fully insured health care program is generally issued under state insurance laws. So what you're going to probably see is insured plan policies in states that permit same-sex marriages will probably automatically provide policies that permit coverage of a same-sex spouse. So in those states, and when you're looking at state insurance laws, you're going to see policies that will that maybe permit or even require coverage of a same-sex spouse if you offer spousal coverage. That's the big if. Under the Affordable Care Act,
a spouse is not a dependent, and you don't have to offer coverage to any spouse, even to avoid the penalty. So spouses are really not in play there. Now, it's a little more complicated if they're self-insured plans. They may not be required to offer coverage to same-sex spouses under current law, but depending on what specific jurisdictions an employer operates, and depending on whether or not they want some uniformity or whether or not portions of their workforce, it may be hard to recruit if they don't provide benefits to same-sex spouses. That may drive that. And also, we don't know yet what could be the potential liability for treating same-sex spouses differently than opposite-sex spouses. But under self-insured plans, arguably you can still limit the term spouse to an opposite-sex spouse. But I think most people are cautioning that depending on whether or not the type of employer you are, for example, if you are a governmental employer, is that going to run afoul of a state constitution because it's somehow state action, or it's going to run afoul of another provision in the U.S. Constitution on due process. So I think that you need to think very long and hard before you say, I'm not going to cover any spouse but an opposite-sex spouse if you're an employer. Now, there may be some state exemptions for religious organizations and so forth. I have not delved into that, but there may be some exemptions out there if it is a religious organization that's offering the program. But the bottom line is, state insurance law is going to control the nature of policies, and many years ago, California required all insurance policies issued in that state to provide domestic partner benefits. So you're going to see that there's going to be somewhat of a state-by-state and insurance carrier within those states as far as what they will offer. But one way is if you don't want to offer it to to a same-sex spouse, then you don't offer it to any spouses at all. Again, I think state insurance law is going to drive the train on that for insured arrangements, and some self-insured plans may decide that they want to take the risk and limit the coverage to opposite-sex spouses.
Great. Thanks, Sally.
Okay, I think we're now on slide number 21. And now that we've gotten this guidance, and again, we're looking at prospective only until we get something else. If you have a same-sex spouse and your plan has covered same-sex spouses in the past you could not reimburse through a health flexible spending account any expenses of the same-sex spouse unless they were your tax dependent. This has now changed under flexible spending accounts, under health reimbursement accounts, and health savings accounts. So if someone's a same-sex spouse, for federal tax purposes, they don't have to be the tax dependent, and those expenses can be reimbursed. You will now see that because COBRA is under the tax code, same-sex spouses can be qualified beneficiaries for COBRA. And if you get married to a same-sex partner, then that would trigger a special enrollment right under the HIPAA provisions that has always applied when opposite-sex couples got married, to let you enroll your new spouse within so many days of coverage. You know, probably most importantly is going to be the big change in the retirement, on the retirement side too. You're going to have to treat a same-sex spouse as a spouse for the purposes of all of the retirement plan protections that are afforded to spouses under the Internal Revenue Code in ERISA. That means a same-sex spouse is going to be subject to all the pre-retirement survivor rights. If someone dies and their spouse is still alive, they're entitled to this pre-retirement survivor annuity. That means the same-sex spouse would get that. to the extent that someone wants to name someone other than their same-sex spouse as a beneficiary. That spouse would have to give consent. If there's no beneficiary designation on file for an employee that dies and leaves a same-sex spouse, then the automatic beneficiary designation is going to be the same-sex spouse. Again, minimum required distributions. There are special tax rules that apply when somebody reaches 70 and a half that makes you pay out benefits. You can't wait any longer than that if you've already terminated employment. The rules for calculating those distributions are different if you have a spouse. And the timing of the payments are different if you have a spouse. Spouses have special rollover rights if they want to take a distribution of your benefit upon your death and roll it over to an IRA. There are special rules for spouses that are much more tax beneficial. Hardship withdrawals under 401k plan have rules that allow you to get a hardship withdrawal because of the hardship of your spouse. Again, those benefits inure to a same-sex spouse. Also, a same-sex spouse now can be an alternate payee under a qualified domestic relations order. Again, when I gave you the one little example of John who wanted to give his or same-sex spouse a joint survivor annuity so that when he died, his same-sex spouse could get benefits under the defined benefit plan, we really don't know what rules will apply retroactively, whether they will be mandatory, whether they'll be optional, and how they're going to work. But that's why, this is so interesting. You're just going to have to stay tuned and see what happens next. All right. Again, here is what I think I just answered this question, but nothing in the law requires an employer to provide any benefits. And if you don't give benefits under the Affordable Care Act, a large employer may have to provide a penalty, but it doesn't say you have to provide health care. And nothing in the Affordable Care Act requires an employer to provide health care to an employee's spouse, same sex or opposite sex. Because a spouse is not a dependent. You do have to make an offer of coverage if you decide you're going to play instead of pay the penalty, but you have to make an offer of coverage to the employee and the employee's dependents, and that does not include a spouse. Now, there's some other Windsor-related guidance, but that doesn't, in some cases, does not directly impact the employer, but this one point is probably good to know, that if you've got people who are out there looking at marketplace coverage and are looking to see if they are eligible for the subsidies to help pay the cost of marketplace coverage, guidance came out in September that said we're going to treat a same-sex spouse the same as an opposite-sex spouse for determining household income. In other words, that may be a negative because you've got to put that income together to determine whether they're eligible for subsidies, and for basically determining your size of your household and determining how much of a subsidy you're eligible for. Now, they did also point out that there are potential issues and benefit eligibility gaps because there are states that will not recognize same-sex marriages for purposes of Medicaid and the Children's Health Insurance Program. And one of the biggest arms of the Affordable Care Act was the expansion of Medicaid to cover more people. And so once again, you're seeing this disparity in treatment based upon not only whether or not the states recognize same-sex marriage, but also under the Affordable Care Act with respect to the states that elected not to expand Medicaid. The Social Security Administration, interestingly enough, under Operations Manual, they have been encouraging people in same-sex marriages to apply. but they have not adopted a celebration or domicile rule. They're looking at both. Did you get married in a state that recognized same-sex marriage, and do you live in a state? And they're granting benefits to those individuals. They're putting some of the others applications on hold. They have a whole regimen in this operations manual, if you want to try to find it, that tells you how they're processing these applications. And as of the last day I looked at it, they were still talking to the Department of Justice, and they're making sure you were married for a particular period of time. You have to be married for a year before you're entitled to some of the spousal benefits under Social Security. And they're also making sure that you got married or claim you got married in a state during the time period when same-sex marriage was deemed to be legal in that state. The Office of Personnel Management also had an announcement that the Windsor decision itself triggered a right to change benefit elections. And so in the federal government, they said, hey, if you come in within 60 days of that opinion, we'll let you make changes. In other words, we'll let you add your same-sex spouse as if you just got married. You can change your life insurance, flexible spending accounts, and basically announced, again, a state of celebration rule. The Department of Defense also made an announcement that they were going to recognize all marriages, and again adopting a place of celebration rule. And they're now extending all benefits to all spouses, whether in same-sex or opposite-sex marriage, and even allowing people to take leave to travel to a state that permits same-sex marriage if they're stationed more than 100 miles away from a state that allows such marriages. In other words, leave in order for them to get married in a state that would recognize it. Okay, I think Catherine's going to talk to us a little bit more about family and medical leave. We talked about it very briefly at the beginning, and the fact that it appeared that the Department of Labor had said it's where you live, not where you celebrated the marriage, but there are a few other complications that Catherine's going to talk to you about.
Great, Sally, thanks. And just to backtrack a little bit on the Department of Defense recognition of all marriages, including same-sex, based on the state of celebration, it'll be really interesting to see if there is an interplay with the FMLA and the military leave provisions, and I'll be exploring that in just a few moments. So let's look at the Family and Medical Leave Act, and some of the things that I'm going to talk about under the FMLA include, again, the definition of covered spouse and the impact on the in loco parentis rules, as well as the impact on military family and medical leave. I'll move on from the FMLA to talk about some impacts on immigration with respect to binational couples and the ability to bring a foreign spouse into the United States. And then we'll talk somewhat about some of the concepts relevant to discrimination in employment, and then I'll end with ENDA. In any event, let's talk a little bit about the Family and Medical Leave Act. Let's just, as a very, very brief reminder, state that the FMLA entitles eligible employees of covered employers to take unpaid job-protected leave for specified family and medical reasons with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. They may take up to 12 work weeks of leave in a 12-month period for the birth of a child and to bond with a newborn child within 1 year of birth, for the placement with the employee of a child for adoption or foster care, and then to bond with the newly placed child within 1 year of placement, for a serious health condition that makes the employee unable to perform the functions of his or her job. And then the most important aspect, or one of the most important aspects, is to care for the employee's spouse, son, daughter, or parent who has a serious health condition, and also with respect to either a qualifying exigency arising out of the fact that the employee's spouse, son, daughter, or parent is a military member on covered active duty, or also to care for covered service members with a serious injury or illness if the employee is the spouse, son, daughter, parent, or next of kin of the service member. Now, understand that the concept of same-sex marriage will have a fairly broad impact on just about every aspect of the FMLA, including the in loco parentis rules, which themselves, when they were issued, had a very broad impact on the FMLA. So let me go back for just a moment to talk about a few specific aspects of the reasons that an eligible employee might take up to 12 work weeks of leave. And in essence, the primary ones would be to talk about would be to care for the employee's spouse, son, daughter, or parent who has a serious health condition. And then again, I'll talk about the military ones as well. But when we discuss the concept of the individual's family member with a serious health condition, the Department of Labor issued what I referred to earlier as Fact Sheet number 28F, entitled Qualifying Reasons for Leave under the FMLA. And in that, they, for the first time, laid out all of the different information relevant to assessing whether somebody constitutes a spouse or a child or a parent and so forth. And so here, the fact sheet identifies spouse, and again, I read that definition to you earlier, but it bears repeating. A spouse means a husband or wife as defined or recognized under state law for purposes of marriage in the state where the employee resides, including common law marriage and now same-sex marriage. The concept of a parent means a biological, adoptive, step or foster father or mother, or any other individual who stood in loco parentis to the employee when the employee was a child. Of course, this term does not include parents in law. The next area is the son or daughter. A son or daughter means a biological, adopted, or foster child, a stepchild, a legal ward, or a child of a person standing in loco parentis who is either under age 18 or who is age 18 or older and incapable of self-care because of a mental or physical disability at the time that the FMLA leave is to commence. And this tends to be quite a broad definition of child, in that the in loco parentis issue is impacted and also has an impact. And so the concept of in loco parentis was adapted sometime back in, I believe it was 2010. And in essence, the in loco parentis rules were expanded. The FMLA basically stated, or the regulations were defining in loco parentis to include those with day-to-day responsibilities to care for or financially support a child. Employees without a biological or legal relationship with a child could nonetheless stand in loco parentis to the child and be entitled to FMLA leave. Likewise, an employee was allowed to take leave to care for someone who, even though they had no legal or biological relationship to the employee when the employee was a child, that individual stood in loco parentis to the employee when the employee was a child, and therefore that child could leave or take leave to care for that individual who had stood in loco parentis to them. I want to talk about that issue just a little bit, mainly because the in loco parentis rules did create some concepts of expansion, and that expansion actually resulted in the concept that one child could have numerous quote-unquote parents based on various broken families and so forth. And so this interpretation basically leveled down or whittled down the level of responsibility that's necessary to establish a parental relationship. And in essence, it didn't prevent a finding that the child is the son or daughter, regardless of whether the child has a biological relationship or a legal relationship. Basically, if you take this to its logical conclusion, it results in a no parents limit, which means that regardless of financial commitment to a child, any number of individuals could be found to stand in loco parentis to a child and be entitled to FMLA leave as that child's parents, in quotes. And so in essence, what we see happening in a number of employer communities is that couples have children, couples break up, couples end up adopting or taking on additional partners with other children, and this can actually extend out multiple degrees to where one child could be deemed to have up to 8 sets of parents. And so it's a fascinating concept, and I think that where we see the common law marriages, where we see really the opposite sex and the same-sex marriages, we're going to see that the in loco parentis expansion is expanded further by the concept of the same-sex marriage, mainly because of the ability of an individual who is married to actually become a quote-unquote parent, or to stand in loco parentis to a child, regardless of whether they adopt them, whether there's a biological or even a legal or financial relationship ultimately going forward. So with that in mind, let's get back to the concept that under family and medical leave, the definition of a covered spouse means has now been adapted by the Department of Labor to include both common law marriage and same-sex marriage. And again, as I pointed out earlier, the DOL has taken the position that it is the state of domicile that matters. I will address the other topics on this slide in future slides, but for with respect to some of the unintended outcomes that might grow from this, we would see the concept of the kind of lessening of the availability of leave. And I think I've missed a slide. I'm going to go back one. Thank you. All right. I want to talk a little bit more about some of the domicile issues that are created here. In essence, then, when we look at the concept of domicile, we are, again, focusing on where the individual lives and whether the state where they live recognizes same-sex marriage. Based on this problem, individuals by the same employer may not qualify for spousal leave under the FMLA. So, for example, determining whether someone is a spouse based on the marriage laws of the state where the employee resides is going to require employers to become more familiar with multiple state laws and, essence, basically its own states, the laws of neighboring states or any states where the employer might have a facility, and then any states where its employees reside. So let's talk about an example. If an employer is located in Pennsylvania, recall I said that Pennsylvania is the last holdout on what we consider to be the East Coast. Pennsylvania is a state that does not recognize same-sex marriage, that an employer who's located in Pennsylvania should be aware that an employee who might live in Maryland is going to be entitled to take FMLA leave to care for a same-sex spouse's serious health condition, even though the state where the employer is located does not recognize same-sex marriage. So here, the Maryland employee or the Maryland domiciled employee will have the opportunity to take family and medical leave even though his employer is in Pennsylvania, which is a state that does not recognize same-sex marriage. Now, a complication can certainly occur if an employee moves from Maryland to Pennsylvania while they're taking FMLA leave to care for a same-sex spouse. That employee would no longer be eligible for FMLA to care for his or her seriously ill spouse under current FMLA regulations. Now, the Department of Labor has issued a statement indicating a recognition that the choice of the domicile rule versus the state of celebration rule is going to create some of these issues. And we're expecting to receive additional guidance from the DOL, I would say at least in 2014. We were hoping for it this year, but it doesn't appear to be forthcoming, at least to my knowledge, in December. So we're looking forward to it in 2014, and we're expecting to see a movement towards the state of celebration. It may or may not require statutory or regulatory changes, but we'll see what the Department of Labor decides to do ultimately, especially since it has been provided with all of the evidence, as Sally pointed out earlier. Now, when we talk about additional unintended outcomes under the FMLA, it's quite possible that a same-sex spouse, a same-sex couple who works for the same employer may actually get less entitlement to leave for the birth of a child because they are not permitted to both take 12 weeks if they work for the same employer. So we see that possible unintended outcome. However, it's basically treating the same-sex couple the same as a married couple in that context. Now, as I talked earlier, the potential impact on the application of the in loco parentis rules simply means that the recognition of a same-sex spouse is that we are expanding the in loco parentis, which is where we used to cover the same-sex spouse. We are now able to approve leave on the basis of the spousal definition in many states, as opposed to via the in loco parentis definition. I will point out that before the Department of Labor came out with the in loco parentis changes, or at least the clarifications is what I like to call them, most employers were looking at the in loco parentis rules and trying to be fair, and in essence, to the extent that someone could show that they had grown up with this individual, or that this individual had been standing in loco parentis to them, employers would typically provide that kind of access to leave. But again, now that we have that guidance from the Department of Labor, it's useful. Let me talk a little bit about the concept of whether an employer should offer both types, whether an employer should offer FMLA leave to employees regardless of whether they live in the state of celebration or the domicile. Getting back to this very briefly, if an employer determines that an employee is not eligible for FMLA leave to care for their same-sex spouse or partner due to the laws of the state where they reside, the employer is still within its rights, obviously, to offer the employee some non-FMLA leave to care for their spouse or partner. In essence, it's a good idea to do that to avoid employee relations issues, and most employers are currently taking that approach regardless of the state laws. Many employers actually are in municipalities or other locales that do have perhaps same-sex protection ordinances, even if their state and the federal government don't provide for it. Now, the caveat here is that when offering non-FMLA leave, employers should be careful not to count that time off against an otherwise FMLA-eligible employee's entitlement. In essence, be careful about how you provide that leave, and be careful not to test it against their entitlement under the FMLA. Again, the DOL expects to revise its regulations in the future and extend FMLA rights to all same-sex spouses regardless of residence. And so at that point in time, if it does occur, then employers can certainly offer FMLA to employees who are legally married regardless of where they reside. All right, let me move on. Military leave. I want to address a couple of things, and if there's time at the end of our presentation, I can come back and do a stronger discussion about military leave. However, I simply want to point out that the military, the leave for qualifying exigencies and the leave for military caregiver are both impacted by the same-sex marriage recognition. And in essence, remember that FMLA leave for qualifying exigencies allows eligible employees to take up to 12 weeks of FMLA leave for a qualifying exigency arising from the fact that their spouse, child, or parent has been called to or is on active duty in a foreign country. And this is where, again, the issue comes up with leave. The family members are generally defined rather broadly, and again, the son or daughter on active duty will include an employee's biological, adopted, or foster child, stepchild, legal ward, or one for whom the employee stood in loco parentis. Unlike other types of leave, though, the age of the child who is called to active duty does not matter. As you heard me say before, the child is limited to those up to the age of 18 or those who are 18 and older who are incapable of self-care, except for under the leave for military qualifying exigencies. Now, with respect to the other type of military leave, the leave for military caregivers, recall that this allows eligible employees to take up to 26 work weeks of leave during a single 12-month period to care for a covered service member who sustained or aggravated a serious illness or injury while on active duty, and the employee may be a spouse, parent, child, or next of kin of the service member. And remember, too, that the maximum amount of leave for military caregivers is not in addition to other types of FMLA leave. Indeed, the 26-week limit applies to all categories of leave taken in a single 12-month period, and it is possible that an employee can take more than 26 weeks of leave in a calendar year if that person takes leave for more than one service member with a serious illness or injury. Again, if they take leave for more than one service member with a serious illness or injury, they can be out for more than 26 weeks. Here, the family members are defined as well, and again, the concept of the Windsor decision and the recognition of same-sex spouses and the recognition by the Department of Defense that employees' same-sex marriages will be recognized based on the state of celebration all point to the need to carefully interpret the Family and Medical Leave Act with respect to the military caregiver leave when you're assessing whether an individual is eligible for care for their same-sex spouse. I would certainly err on the side of using the state of celebration rule here as opposed to the state of domicile. You would be giving leave where it might not necessarily be required under the Family and Medical Leave Act. However, again, under the Department of Defense rules, I would say that the state of celebration is clear evidence that the intent is to permit military members and their families to take the family, medical, military leave as needed. All right, let's talk a little bit now about the next slide, and that relates to same-sex marriage and binational couples. In essence, binational couples are couples that live apart, or perhaps one partner is from another country. And shortly after the Supreme Court's decision in Windsor, the Department of Homeland Security instructed the USCIS to review immigration visa petitions that were filed on behalf of legally married same-sex spouses in the same manner as those filed on behalf of opposite-sex spouses. So in essence, USCIS will be reviewing immigration visa petitions for legally married same-sex spouses in the same fashion as those filed on behalf of opposite-sex spouses. Of course, though, this doesn't change the fact that it can take several months for a couple to even get an interview with the Immigration Service after having filed an application for a marriage-based green card or a change in status. The other aspect of this is that the USCIS will be reopening all petitions and or applications that were previously denied on account of DOMA on or after February 23, 2011. The USCIS will attempt to notify the filers of those petitions and or applications of the reopening and the request, and they will request updated information to support the application for a green card. Finally, it's important to note here, and this is where it becomes a little bit interesting, the USCIS has said that it is now processing binational same-sex marriages the same way as opposite-sex unions, and does not differentiate by orientation, but by length of marriage. And so this is an interesting factor because the length of a marriage is very interesting, where couples who have been married less than 2 years are going to be subject to more scrutiny. And that can certainly work against same-sex couples because many states have only recently begun to allow same-sex marriage, and because the couple may also have been reluctant to publicize their relationship until recently. So in essence, I think that you'll see that the impact on same-sex couples is going to continue to be a little more difficult than for opposite-sex couples, simply because the length of their marriages may not be quite up to the USCIS's expectations, and so we'll probably see more same-sex couples flagged for review than opposite-sex couples simply based on the length of their marriage. Okay, and that leads us then to a discussion about discrimination and ENDA to some degree. Remember that sexual orientation is not a protected class under federal law except for federal sector employees. Many jurisdictions do prohibit sexual orientation discriminations, but many jurisdictions do not. And as a result, we're going to probably see a move towards updating Title VII to include sexual orientation within the sex discrimination provisions. We'll see a move towards updating other federal discrimination laws relevant to protected classifications, including this as a new protected classification. We'll probably see a lot of the states that recognize same-sex marriage, if they haven't already recognized sexual orientation and related categories, to include those in their disparate human rights or human relations discrimination statutes. Now, the Employment Non-Discrimination Act, called ENDA, has finally passed the Senate for the very first time in its incredibly long history. This is a law that has been bouncing around, has been introduced and reintroduced for decades. Well, I don't know if it's decades, but it's many, many sessions of Congress. And so on November 7th of this year, the Senate finally passed the ENDA with a final vote of 64 to 32. And this is the first time that the Senate has actually passed ENDA. Now, ENDA would prohibit covered employers, employment agencies, and labor unions from using an individual's actual or perceived sexual orientation or gender identity as the basis for employment decisions, such as hiring, firing, promotion, or compensation. And the bill defines sexual orientation as homosexuality, heterosexuality, or bisexuality. Gender identity is defined as the gender-related identity, appearance, or mannerisms, or other gender-related characteristics of an individual with or without regard to the individual's sex at birth. And, of course, would not be applicable to small businesses with less than 15 employees, or religious entities exempt from Title VII's prohibition, or the military. And that's an interesting dichotomy right there. But I believe that will change if ENDA doesn't pass this time around. I would expect that the newest version of ENDA might include military coverage as well, based on the Department of Defense's recent pronouncements. Now, other concepts behind ENDA are that it would create some federal causes of action for disparate treatment and retaliation claims, but would not permit disparate impact claims. So under ENDA, an employer wouldn't be required to justify a facially neutral policy that might have a disparate impact on employees due to their sexual orientation or gender identity. And ENDA also does not abrogate an employer's right to establish a reasonable or otherwise lawful dress and grooming policy, provided that the employer has been put on notice of an employee's gender transition and allows the employee to dress or groom pursuant to the standard the employer applies to the sex to which the employee has or is attempting to transition. And so I would tell you that currently 21 states in the District of Columbia have legislation prohibiting employment discrimination on the account of sexual orientation, and 17 of those states and the District of Columbia include gender identification and protected characteristics. I would also tell you, too, that the 29 states that don't have these statewide types of legislation already have multiple municipalities, cities, counties, and so forth that have passed similar anti-discrimination measures. And in essence, many, many employers currently include gender identity and sexual orientation in their non-discrimination policies anyway. But it's going to be interesting to see whether ENDA passes the House this time around. Most commentators don't expect it to do so, but I do believe that we will see ENDA become law in some form or other in the future. And with that, I think we're moving towards some action items. And I'll take this first one, and then I'll turn it back to Sally. In essence, the action items are to review your FMLA policies and to focus on whether employees who reside in a state recognizing same-sex marriages will be entitled to leave to care for same-sex spouse. And I talked earlier about whether to accept both state of domicile and state of celebration rules for purposes of leave. And with that, I'll turn it to Sally to see if she can run through the remainder of this program. Hello?
This is Lori, and Sally is going to speak to some of the benefits issues, but in connection with that, one reminder for employers is that even very mundane things can cause problems in flipping your policies and plans over. One of the things that we need to sort of do a test drive on when we're making these changes is in our systems themselves. So for instance, if you have folks signing up for benefits in an online system, check your system to make sure that it's not going to kick out a spouse as a beneficiary if the insured individual, the employee, and the spouse are of the same sex. And so it's the details like that that oftentimes have the most visibility to your same-sex couples. And those are things that sometimes we tend to overlook when we're making some of these changes. And Catherine, I had just a very quick question for you. With respect to employers with operations across jurisdictions, are you finding that they are taking an approach of adopting the same policy across company, regardless of which state exactly employees are located in when it comes to addressing these changes?
I am finding that employers are more likely to just permit this to occur regardless of their obligations, and the reason why is nobody's really interested in differentiating between states, particularly where state laws have been changing, and particularly where the expectation is that at some point in the very near future we're going to be in a celebration mode as opposed to a domicile mode anyway. So I think employers are accepting it, and those who aren't are just having a difficult time, mainly because they are encountering a lot of record keeping and non-FMLA leave issues. So I think employers are taking this one on the chin and waiting for further guidance and hoping that it comes soon.
Sure. Well, in connection with our remaining action items, you'll see on the slides that essentially what employers need to do at this point is take a look at their plans and the ancillary plan documents, make sure that they're in compliance, make any amendments that are necessary. And then the other key thing will be to make sure that the tax withholding practices are consistent with these new rules that we've got in play. And then another key point to end with, I think, here today is that as the legal landscape changes and as employers move to modify their benefits plans, their policies, etc., clear communication with the employee population is going to be key to making sure that these things go smoothly, and that when there are glitches here and there, that you've got the goodwill within your employee population to allow you to make those corrections without ruffling too many feathers. So communication, as always, is key. Catherine, did you have anything else to add?
In addition to communication, it's stay abreast of the law as well as you can, because it's changing and it's changing fast.
Thank you all. We've reached our conclusion. And on behalf of LexisNexis, I would like to thank Catherine and Sally and Lori for an excellent program today. Thank you all, and have a great day.